All right. Good morning, everybody. My name is Craig Subocz. I'm a Senior Associate at Russell Kennedy, and we're about to start the first webinar concerning privacy and data security in health and aged care. Just wanted to thank you all for giving about an hour of your time this morning to listen to me present on privacy and data security. With respect to questions, we have a chat box available. So if you have questions during this the webinar, please feel free to type them into your chat box. If I can just ask if you have any mics, if we could get them muted, that'd be fantastic, just so we don't have extraneous noise interrupt the presentation. And I think without further ado, we'll get cracking. So just the usual disclaimer, we're not intending this webinar to contain legal advice on specific issues. It's regarded as general commentary. Should you require specific advice, please feel free to contact me post the webinar. So the agenda this morning, we're going to have a quick recap of privacy laws. Hopefully most people are familiar with the privacy laws in Australia at the present time. We're going to take a look at the 3 case studies which have been made available for download prior to the webinar. And then we're going to look at mandatory data breach reporting, which is the new and, for me in particular, exciting aspect of privacy law. And then we're going to talk briefly about what to do next. So without further ado, let's get cracking into it. Recap of the privacy laws. Most people will be familiar with the changes to the privacy laws that occurred almost 4 years ago now. Prior to March 2014, we had the National Privacy Principles. They were replaced in March of 2014 with the Australian Privacy Principles. The credit reporting regime, which I won't touch on this morning, was rewritten to greatly extend the protections to consumers. The Privacy Commissioner gained expanded powers to investigate privacy breaches, and penalties for privacy breaches were significantly increased and currently stand at up to $1.8 million for corporations if they're persistent and serious breaches of privacy. And of course, as I touched on just at the start, from February next year, there will be an obligation to report data breaches, and I'll touch on that and discuss that further in due course. All right, so privacy laws. As I said, Privacy Act regulates the collection, use and disclosure, the quality and security and access to and correction of personal information. It's worth bearing in mind that the Privacy Act is geared towards protecting the rights of individuals rather than entities that collect and use information. So we tell our clients that that's worth keeping in mind, because that's how, if the Commissioner is ever investigating a potential or alleged breach of privacy, that's how the Commissioner will approach the matter. Health providers and most aged care providers must comply with the Privacy Act. Health providers that deal with health information are caught regardless of their annual turnover. Entities with an annual turnover in excess of $3 million per annum must comply with the Privacy Act. The touchstone, or the fundamental aspect of the privacy legislation, is that it protects personal information. There is a statutory definition, but for the purposes of this morning's webinar, essentially personal information is information capable of identifying an individual. So, for example, person's name, their present address, telephone numbers, email addresses, dates of birth, all that information could be regarded as personal information. It also includes an opinion that someone might form about an individual, and it's regardless of whether the information or opinion is true or not. Sensitive information is a subset of personal information. It includes health information, such as information about the treatment an individual has received from a medical practitioner, expressed wishes about future medical treatment or medicines to be prescribed, things of that nature. It also includes information about an individual's ethnic origin, their sexual preferences, their membership of a trade union or professional association, whether they have a criminal record, and so on and so forth. Essentially, the Privacy Act mandates compliance with 13 Australian privacy principles. Won't go into each of them because we'll be here all morning if I did. but essentially how an entity complies with the Australian privacy principles is set out in a privacy policy. On the slide that is currently shown is an extract from Russell Kennedy's own privacy policy that is available via our website. Basically, it goes through about how we collect, use, dispose of, disclose personal information that we collect as a law practice. Many of you would also be familiar with the Health Records Act, which in Victoria mandates health providers to comply with the 11 health privacy principles. There is, of course, a lot of overlap with the Australian privacy principles, but also some significant differences. It deals with the sale or closure of a health provider and the making of health information available by a health provider to another health provider. And there are also equivalent legislation in other states and territories that regulate the collection, use and disclosure of health information. Again, if I was just to talk about the Health Records Act and the equivalent legislation in other states and territories, we'd be here all morning. I'm sure everyone else has got better things to do, so I'm just going to leave the recap of the privacy laws there. So just a quick reminder, if you have any questions about the presentation so far, please feel free to type them into the chat box. I think with the number of people we have on the webinar at the moment, rather than try to answer them as we go along, it might be easy if we leave them to the end of the presentation. We should hopefully have 10 to 15 minutes time available to go through any questions. So again, just a quick reminder. So we'll dive into the case studies, and what the slides do will be to summarise the facts and circumstances of the case studies. The details will be in the handouts that were available for download. So the first case study deals with the disclosure of health information to the police. This case study is based on a Privacy Commissioner report that he issued some time ago. And the facts have been summarised from the Privacy Commissioner's published report. So what happened was that Mr. Z believed that a neighbour had damaged his own property. He called the police to report the property damage. The police attended Mr. Z's premises and observed him to be acting in a highly excited and paranoid fashion. A police officer attempted to contact Mr. Z's doctor, Dr. Y, who worked at a medical centre. Dr. Y was not available, so the police officer was transferred to another doctor who noted in Mr. Z's medical notes that the police had attempted to contact Dr. Y. Subsequently, the police managed to get in touch with Dr. Y and asked her for her opinion on whether Mr. Z was psychotic. Dr. Y said it was possible, but further assessment was needed. And it should be noted that all this information was noted by the police in their records on the case. So Mr. Z submitted an FOI request to the police seeking records of the police's investigation into his complaints, and based on the records disclosed by the police, complained to the Privacy Commissioner that Dr. Y had interfered with Mr. Z's privacy. During the investigation, Dr. Y conceded that she had disclosed personal information to the police, but she argued that she acted in good faith, assuming that the officer was sufficiently concerned to contact her to request such information, and that formed the basis for her reasonable belief that Mr. Z posed a serious and imminent threat to himself or to the public. The Commissioner completed his investigation and determined that Dr. Y had interfered with Mr. Z's privacy. The medical records held by Dr. Y's practice did not note in any way that Dr. Y had been concerned prior to the police contacting her that he might have posed a serious or imminent threat to himself or to the public. Dr. Y admitted to the Commissioner that she could not recall a suggestion of such a threat ever arising. Dr. Y further admitted that she did not ask why the officer had contacted her. So the Privacy Commissioner ordered Dr. Y to apologise to Mr. Z for the breach of privacy and to pay him $6,500 compensation for the interference with his privacy. So from our perspective, the key takeaways from the first case study is that disclosure of personal information to law enforcement is not automatically permitted under the Australian privacy principles. It's worth noting that a privacy policy could set out the usual recipients of personal information, and we often recommend when we're preparing privacy policies for our clients that The general or usual recipients of personal information are set out in the privacy policy, so that individuals about whom you're collecting personal information can be made aware of the possibility that their personal information, which includes their health information or other sensitive information, could be disclosed to certain kinds of individuals or recipients. We'd also recommend that if you don't already have internal procedures, that you take the time to prepare some procedures to enable your staff to respond appropriately to requests for information. Obviously, in the aged care setting, you're going to deal a lot with family members who want to understand the situation that their loved one is in with respect to receiving aged care services. So dealing with a request for information from a family member who doesn't understand why they're not receiving that information as soon as they pick up the phone is useful. Obviously, police may contact an aged care provider or a health service provider seeking information about a recipient of care. And obviously, training staff on those procedures would be recommended. If in doubt about whether to disclose personal information to a third party, we would recommend that you seek advice, because from next year, improper disclosure of personal information may constitute a reportable data breach. I'll discuss data breaches and the obligation to report them in further detail momentarily, but from our perspective, a lot of people think that data breaches are what gets into the public when someone gets hacked and records are uploaded to a website and stolen for the use by someone on the dark web. And that's certainly one aspect of data breaches, but from our perspective, the legislation doesn't differentiate between that type of situation and a situation where personal information might be disclosed with the best of intentions, but in breach of the legislation. That would constitute a data breach, and if it is sufficiently serious enough, the individual or the entity affected would need to report that data breach to the individual and to the Privacy Commissioner. So as I said, we'll come to that very shortly once we get through the case studies. Excuse me while I take a sip of water. Again, just a quick reminder, if you have any questions about the case study, please feel free to type them into your chat box and we'll get to them shortly. So moving on to the second case study. This one obviously made the mainstream media last year because it was such a significant data breach. In October 2016, the Red Cross Blood Service became aware that a database containing 550,000 records of donors was uploaded to a publicly accessible website. It's worth noting that the Red Cross Blood Service did not become aware of this until a third-party cybersecurity expert actually drew their attention to the fact that the records were publicly available and accessible, because he himself received a tip-off anonymously from someone who had stumbled across these records. The records contained contact details of individual donors and sensitive information about the donors' history. It included answers to questions regarding their at-risk behaviours such as drug use, sexual history, things like that, blood types and other medical history. We have a question just come up from Stacey. Thanks, Stacey, about who could we seek advice from regarding whether to disclose personal information to a third party. Quickly answer that one because it's fairly easy to answer. Basically, you'd want to get advice from a legal practitioner, essentially. The Privacy Commissioner is not in a position to provide advice to entities that he regulates, primarily because he's a regulator and his job is not to provide legal advice, but to regulate and enforce the privacy legislation. So bottom line, get a legal opinion. That one's fairly easy to answer, but thanks for your question, Stacey. I think at this point we might actually get to some polls. We have some polls set up. So just while we're going through the case studies, we might click on a poll. So this one is just about whether you started thinking about training needs for your staff in this area, given the impending data breach legislation coming into effect. So feel free to click yes or no on that poll. It's a pretty simple question, and it'd be much appreciated if you could answer that. So back to the second case study. So once the Red Cross Blood Service became aware of the fact that so many donor records were publicly accessible on the internet, they took urgent steps to have the database removed, and they released a public statement apologising for the breach. The Commissioner commenced an investigation on the 27th of October and took 10 months to complete the investigation and to publish his findings into the investigation. The results of his investigation are publicly available on the Privacy Commissioner website. They're pretty well written, pretty clearly written, and worth reading because there's some interesting information and some tips for entities that handle personal and sensitive information about how to deal with contractors. Thank you. So according to the Commissioner, what happened with this data breach was that an employee of a contractor engaged by the Red Cross Blood Service uploaded the online database on the 5th of September. So essentially the database was available for approximately a month before the Red Cross Blood Service became aware that it was there. The Commissioner found that the breach was the result of a once-off human error. It was neither authorised by the Red Cross Blood Service or its contractor, and obviously fell outside the scope of the contract between the Red Cross Blood Service and the contractor. Essentially, the contract between Red Cross Blood Service and its contractor was to manage its digital presence, its online websites, and including a website that enabled individuals to register their interest in becoming a blood donor and to answer questions about their history. But the Commissioner found that the Red Cross Blood Service had contributed to the circumstances giving rise to the breach, and we'll talk about that in a moment. So the Commissioner found that the Red Cross Blood Service had no measures in the contract to ensure that the contractor had adequate security protection for the information that it handled and was disclosed to it by the Red Cross Blood Service. The Red Cross Blood Service took no steps to assess the security measures and practices of the contractor before executing the contract with the contractor or the service provider. The Red Cross Blood Service had not taken the time to clearly define the requirements that it would like contractors to meet regarding information security, bearing in mind that the information that they handled was of a particularly sensitive nature. Additionally, once the information had been used to make appointments for donations, the information, according to the Commissioner, was no longer required, and therefore the Red Cross Blood Service was under a statutory obligation to destroy or de-identify that information, and that didn't occur. I'm just going to quickly end the poll and switch back to the chat to see if there's any more questions on these so far. And we do. There's a question come in from Robin about attendance to the AFP. We might just pause on that one to answer that one once we end the case studies before we move on to the mandatory data breach reporting. So just hold fire on that one. So according to the Commissioner, following its discussions and investigation of the Red Cross Blood Service, the Red Cross Blood Service has taken a number of steps to make sure that what happened just over 12 months ago doesn't happen again, or the chances of that happening again are minimal. The Red Cross Blood Service has reviewed and improved its practices in relation to handling of personal and sensitive information. It's taken steps to destroy all the historical data from its website, and now has implemented a practice of purging the information it collects through the website fortnightly. It's limited the scope of the information it collects through the website, with the more sensitive information collected through the call centre by trained operators. It has engaged third-party consultants to review incident management response and data security governance, and prior to entering into any significant contract where personal or sensitive information might be accessible by the contractor, it will complete a privacy impact assessment to determine the impact of that contract on the privacy of individuals. So if we look at what's coming down in the next few months, the breach obviously would have qualified as a reportable data breach. That's not on the basis of the number of affected individuals. That isn't relevant to whether a breach is reportable. It's more to the fact that the information that was subjected to the data breach was so sensitive that a single individual who had their information disclosed, that would be sufficient to attract the obligation to report the data breach had the data breach occurred post-February 2018. So from our perspective, for both health service providers and aged care providers, we think the key takeaways from this case study are as follows. If you're going to engage external contractors to handle or who may have access to some personal information, particularly of a sensitive nature, we recommend that you take a look at their data security measures that they will implement to protect that information. A lot of contractors, particularly in the IT space, which is where I play, a lot of contractors will make certain representations at face value. We would recommend that that's useful, but it's not the be all and end all. We recommend that you do some due diligence prior to entering the contract and make sure that the contract deals with information security on an express nature, so that there's clear understanding of what the data security requirements are for contractors to meet, and also understand what will happen if the contractor suffers a data breach that affects the information you've made available or accessible to them. As I discuss in a few moments' time in relation to the data breach notification laws, a data breach that affects multiple parties, they must decide between themselves who is to make that report. So it's important to understand what happens if there is a data breach. All right, so before we get on to the case study 3, we'll go back to the question that was asked in relation to an AFP attending a residential aged care facility or residents under the guise of the coroner's request and without an order. Are you obliged to provide this information? It's a very good question. I think in this situation, if they need to prove that they have a legal right to the information and that you're obliged to provide that information, because without that obligation clearly set out either in a subpoena or something equivalent, you do run the risk of breaching privacy of the affected individuals. Employee records are treated as being confidential under the Fair Work Act rather than under the privacy legislation, but similar situation applies in that circumstance. I wouldn't be giving the AFP or any police officer the information straight away simply because they ask for it, because if you think back to the first case study, the police officer simply asked a question of Mr. Z's treating doctor. She disclosed personal information and it was held to be breaching the privacy of Mr. Z's information. I just had another question come in from Marie as well. Under the new legislation, are we able to notify family members regarding health incidences such as falls should the family not have a power of attorney? Again, it depends on the circumstances. If the person who has suffered the fall or the other incident has the capacity to consent to that disclosure, then if you had that consent, then that's fine. But if they don't have power of attorney, it becomes difficult because it would be a situation where you are potentially breaching the individual's privacy, unless you can say, unless you're convinced that you need to do that in order to protect the health of the individual concerned. So again, we would err on the side of caution making such disclosures unless you have consent of the individual. So hopefully been able to answer both questions in relatively straightforward fashion. Kick on to, oh, sorry, I've gone one too far. Here we go. Technology, how great is it? Case study number 3, disruption of entire hospital network. We combine a couple of incidences into one case study. Obviously, the most well-known one occurred early this year when the WannaCry ransomware spread around the world. Australia was actually reasonably well insulated, primarily due to time differences, if you can believe that, because WannaCry struck, I think, in the middle of the night Australian time, and there was time available to protect Australian networks. So a lot of businesses weren't actually affected. But one entity that was significantly affected by WannaCry was the National Health Service in the UK. they suffered a significant disruption. A lot of hospitals in the UK suffered significant disruption to the fact that they had to cancel surgeries and other health treatments for their patients. Similarly, 18 or almost 2 years ago now, the Royal Melbourne Hospital suffered a Qbot malware infection. The primary vector of attack for both WannaCry and Qbot was phishing emails. So most people with an email address will have suffered or been subject to an email that doesn't look quite right. It attempts to look legitimate, but if you look at the email header, it comes from an address that isn't the same as the address from which a purport was sent. There might be some strange ways of spelling things in the email, so on and so forth. They're pretty much going to be phishing emails, but you'd be surprised to find how many people think that they do look legitimate, click on the attachment that's part of the phishing email, and then suddenly the network is infected. And once the malware is in the network, basically they open the gates to allow further copies of the malware to be infecting the network. So essentially that's what happened with both WannaCry and Qbot. The key takeaways from the case study, basically improve your cybersecurity. Often individuals are the weak link in cybersecurity. I hate to say it, but it's often the case. Password protection is a low-hanging piece of fruit. Are they changed regularly? Do individuals on a computer network need to change their passwords and can't use previous passwords? So those types of fairly easy things to implement. WannaCry and Qbot both spread by exploiting vulnerabilities in Microsoft Windows operating system. Those vulnerabilities were well known and were reasonably easy to patch if the updates that Microsoft made available were implemented. It is a pain in the neck. I often have to update my own personal computers, and you sit there thinking, oh, is this actually working or not? But and you feel like you're losing productivity. But essentially what they're doing is making sure that those vulnerabilities that are identified are patched and inaccessible for malware and other types of ransomware to attack. And finally, maintain current cyber protection software such as anti-spyware, antivirus, firewalls, etc. It's pretty low-level stuff, but the benefits of implementing pretty basic cybersecurity protection is manifest. The one thing that we haven't included on the slide but is worth also investigating is the cyber risk insurance. A number of the big insurers are now starting to offer cyber risk insurance. That is particularly useful if, for example, you are spearphished and end up paying money to someone that was exploiting particular vulnerabilities. So it's worth looking at cyber risk insurance as well if you don't already have it. Other key takeaways that we recommend you look at: if you're disposing of old hardware, making sure that the files on the hardware is deleted or destroyed before the hardware is discarded or sold. Two-step authentication, particularly where you're accessing or your staff are accessing systems that contain particularly sensitive information. And I don't just mean sensitive information as the Privacy Act talks about it, but information relating to the nuts and bolts of your business, financial records and things like that. Two-step authentication basically means, in addition to using a password, the system generates an SMS code that is sent to a mobile phone, and you need to input that SMS code to access the system. We would also recommend that if you don't deal with staff training or staff that deal with confidential and sensitive information, take the time to update and train them on policies relating to the handling of confidential and sensitive information. And in the event that your system is attacked by malware or spyware or ransomware, look at how you can recover from such a disaster and what plans you have from business continuity. And if you do have those plans, regularly test them and update them to make sure that they're up to date and capable of being implemented. So I think at this point we might see if we can start another poll. So just bear with me while we get it up and running. So we've just got a new poll just up for you to click on. So please take the time to answer that poll. All right. So just again, pause there for a moment because that's the end of the case studies. Just to again invite you to input some questions you might have regarding the case studies or anything we've covered so far. Again, the mandatory data breach notification laws will spend some time to get through them. And if we should have some time at the end of the presentation to discuss the questions that might be started up. All right, so I talked about earlier the magical date of February 2018. The mandatory data breach notification obligation went through Parliament earlier this year, but it was determined that in order to give entities regulated by the Privacy Act time to prepare for it, that the obligation would commence on the 22nd of February 2018. So we now have less than 3 months before the obligation takes effect. And of course, as my children make me well aware, we're under almost 3 weeks away from Christmas. We then had the January slowdown, and before we know it, we're back into February 2018, and it's 3 weeks away, if that. So what does this all mean? Basically, the obligation is on entities regulated by the Privacy Act to report to the individual concerned and to the Privacy Commissioner a data breach that is likely to result in the individual suffering from serious harm. The legislation sets out a number of factors which we'll come to in a moment, but essentially the harm does not necessarily need to be financial. It could be mental, it could be physical, it could be other forms of harm. The obligation to report will be avoided if you're able to take steps to avoid the harm from occurring once the data breach is identified. And as I mentioned earlier, multiple entities affected by the one data breach will need to decide between themselves which entity is responsible for making the report. So what we've been telling our clients in preparation for the obligation to commence is that if you are engaging a contractor who has access to some sensitive information, you should be the ones taking charge of making the report because, as we'll touch on in a moment, there's a reputational issue to consider. And you don't want someone who doesn't have your reputation at heart making that report on your behalf. So if we think back to the second case study in relation to the Red Cross Blood Service, under the new scheme, had it been effective 12 months ago, the Red Cross Blood Service would have been obliged to notify the donors. They ended up doing that anyway, but that was on a voluntary basis. So the Red Cross Blood Service would have had to notify the donors affected and the Privacy Commissioner. As we'll come to in a moment, there is statutory information to be included in the notification, but we consider that there is scope to manage the message to minimise the harm to reputation and also to be prepared for any potential litigation that might result as a result of the data breach. So I think at the moment we'll just go back and end the poll and get back to the chat box. Bear with me a moment. All right, so again, feel free to type in some questions in relation to the case studies or to the mandatory data breach notification obligations, and we'll get to them shortly. So the legislation sets out a number of factors in deciding whether the breach is likely to result in a serious harm to any individual. And as I mentioned earlier, it's enough if one individual is likely to suffer from serious harm as a result of the data breach. That's how broad this obligation will be. So the factors are, as the slide suggests, the nature of the information concerned, the sensitivity of the information. So in our view, the health and aged care sectors are going to be ones that really need to look at this obligation in the context of their businesses, because obviously you're handling sensitive information on a daily basis. Information that, if gets into the public domain without authorization, really could end up causing the individuals concerned some serious harm. It's worth bearing in mind that the cyber criminals that focus on extracting information that they shouldn't gain access to from computer networks are increasingly targeting hospitals and other other health providers and also aged care providers to a lesser extent, because they understand the value of the information and the capacity that they have to make money out of it. So it's worth bearing in mind that we think cybercrime relating to the health and aged care sectors is probably going to increase significantly over the next couple of years. So combine that with this obligation to report and you can see it probably in the gun. The other factors relating to deciding whether serious harm is likely to occur or befall individuals affected by the data breach is whether security measures protect the information. So things like encryption, whether the databases are encrypted or not, and also the likelihood of the capacity for those security measures to be defeated or overcome in some fashion. If the encryption on the database is pretty strong and it would take a long time for someone who has access to the database to break that encryption, the chances are it's less likely to result in serious harm affecting the individuals whose information has been breached. And it's less likely you would need to disclose or report that breach to the Privacy Commissioner and to the individuals affected by the breach. Another factor is who could have attained or who could obtain access to the information and the nature of the harm. And as I said earlier, the harm doesn't necessarily need to be financial. It could be mental harm or risk of mental harm or physical harm occurring. So these are the factors that are involved. And obviously, since the legislation has not taken effect, we don't yet know how it will occur in practice. But if you have any questions about deciding serious harm, please feel free to type them to the chat box and we'll have a discussion about them shortly. So the legislation sets out parameters or scenarios where reporting is not required. We've listed these in, I think, in the order of priority from most likely to least likely. So remedial action is taken to prevent the serious harm to the affected individuals before they suffer the harm. The notification is not required if it would be likely to prejudice law enforcement related activity in relation to the data breach, or if notification would be inconsistent with a secrecy provision, then notification is not required. So as I mentioned earlier, we take the view that the likelihood of reporting not being required goes from most likely at the top to least likely at the bottom. So focusing on the obligation to obligation to report being excluded if remedial action is taken. The no obligation to report is likely if the action taken means the breach becomes unlikely to result in a serious harm to affected individuals. Obviously, what the action taken will depend on the circumstances of the breach, who might be affected. It's all hypothetical at this moment in time, but if you're able to take action to prevent the data breach affecting the individuals, then you don't need to report. If the action you take prevents harm from occurring from some but not all of the affected individuals, the obligation to report is shrunk to the extent that you need to only report to those affected individuals you haven't been able to save from exposure to serious harm, and also to the Commissioner. So it's a reduced obligation, not a completely avoided obligation in that scenario. As I've mentioned previously in the presentation, if there's more than one entity affected by the data breach, then only one entity has to report the breach for all of them to discharge their reporting obligation. It's up to the entities themselves, according to the legislation, to determine who or which party will be responsible for the notification. So as I mentioned earlier, if a breach affects a contractor who is handling or has access to personal information that has been collected by US the customer, we would recommend that the customer, so you in that situation, makes the report because, as I mentioned earlier, it relates to reputation management and forestalling potential litigation that might ensue as a result of a claim of breach of contract, for example. So we would suggest a more proactive approach dealing with contractors than allowing them to take the lead. So the legislation sets out obligations as to when and how to notify. If affected by a serious data breach, the entity must notify the individuals at risk of serious harm and the Commissioner as soon as practicable. Any method can be used so long as it is reasonable, but it must be proactive. Obviously, contacting the affected individuals directly would be preferable. But for example, in the Australian Red Cross Blood Service scenario, where donor records of over 500,000 records were affected, individual notification would not have been reasonable. So in that circumstance, publishing a notice on the website and via other channels would have been sufficient to discharge the obligation. The legislation sets out what needs to go into the notification, and as the slide suggests, it is the identity and contact details of the entity affected by the breach, a description of the breach, what information was contained in the breach, and recommendations about steps to take in response. So we would urge some caution in relation to making this notification post-February 2018. Essentially, you may be admitting to a breach of contract, for example, if there's some contractual terms in place that is affected by the breach. So it's important to understand what the ramifications are of making this breach notification, but bearing in mind you are under a statutory obligation to make the notification. So you can't just put your head in the sand and avoid your obligations under the legislation, because essentially if you fail to comply with this statutory obligation, it is treated as a breach of privacy. And as I mentioned earlier at the start, some significant penalties can apply to an entity that is found to have breached an individual's privacy. We have a question from Deborah Gordon that's just come through. Deborah, we might just hold off your question for the time being, just get to it at the end, just in relation, once we finish the discussion on mandatory data breach notification, if that's okay. So come to what to do to prepare. In our view, prevention is obviously better than cure. It's a well-known maxim, but it applies in this situation just like in any other situation. What we mean by that is if you have the capacity to understand what historical personal information your organisation still holds on to and understand whether that information is still required, if you take that time and delete or de-identify the information that you no longer need, then once that data is gone, obviously it can't be subject to a data breach. We would recommend at this point in time, it's a good time to assess and update your privacy policy. We would also recommend that you look at your contracts with your key suppliers to understand the types of information that they may have access to, how they deal with that information, what their obligations to destroy or identify that information once they no longer need it, and obviously reporting around data breaches. We've mentioned it before, but we'll mention it again, training staff on privacy compliance and also training staff on how to identify a potential breach so that if it's possible to nip it in the bud before it becomes a full-blown data breach, all the better. And obviously, sometimes, despite all the best efforts, a data breach may still occur, accidents do happen. Developing and testing a data breach plan is advisable. And that is a good segue into the next slide. As an IT lawyer, I love Dilbert, so it wouldn't be a presentation without having at least one slide with a Dilbert cartoon on it. As I just mentioned, sometimes the best prevention won't stop the breach from occurring anyway. So we would recommend that you have a plan to deal with a breach rather than what's on the Dilbert comic or strip about panicking. Because in our view, being caught without a plan is a recipe for losing control of the message. If you lose control of the message, obviously you're at risk of losing control of your reputation. The plan is an important tool to manage a breach. It sets the structure for managing your response to the breach and to complying with the statutory obligations that will take effect from February next year. We don't believe it's necessary for the board to be involved in the day-to-day preparation and testing of the data breach plan, but they should be aware that the plan is in place and have endorsed it. The plan should include steps to take if a staff member suspects or discovers a data breach has occurred, who comprise the members of the data breach response team, both internal to the organisation and external, the actions the response team should take, and a communication strategy to deal with the reporting obligation. If a data breach is detected, obviously under the legislation when it applies from February next year, it's important to respond promptly. We take the view that the data breach response team should report to a team leader and then up to chain to the CEO and ultimately the board. If your organisation has a privacy officer, it's a good idea to include your privacy officer as a member of the team. Someone with a legal background, either someone internal, such as a general counsel, or if you don't have a general counsel or an internal legal team, an external legal advisor. Risk management support, ICT and HR. Sometimes the data breach might be an IT-related issue. Sometimes it might be a HR support issue. So, for example, an aggrieved former employee has taken information or records from the organisation. So, understanding those circumstances would be important. And we also recommend that someone with a PR or communications background, ideally with media training, should be involved in the response team. There's another question come through from Christina. Again, we'll just part that one to for the end of the session. And Melissa, I think the PowerPoint accessible following the webinar. I think they should be. Yeah. So responding to a data breach, we had some do's and don'ts. We would recommend that you act expeditiously or quickly to a data breach. We do recommend that you act proactively, be honest, get assistance if you think it's necessary, do everything you can to contain the breach. Obviously, there's one thing about responding to an obligation to report, but there's also steps that need to be taken to close the breach down as quickly as possible to make sure that the damage is contained. Evaluate the risks to the individuals exposed if you're capable of doing that. That's important to understanding whether a serious harm is likely to occur to the individuals. If you believe that the risks are minimal of serious harm, then yes, you're on the side of not having to report. So that goes to the next step of determining whether notification is necessary. Obviously, taking steps to prevent the breach from occurring again is important. We recommend, particularly dealing with individuals whose sensitive information may be exposed, to communicate with empathy and transparency. And as I mentioned earlier, investigate and obtain insurance. We recommend that you don't panic, don't ignore the issue and pretend it will go away. Don't be dishonest. Mentioned earlier the risk of litigation ensuing from a potential data breach, but you have a statutory, or you will have a statutory obligation to report a data breach. Letting concerns about being sued, we don't recommend stop you from complying with your obligations, and don't be reactive. So a quick summary, and then we'll get to the questions that have been asked. We've seen through the presentation that personal information is handled, used and disclosed every day. This holds even more true for the health and aged care sectors, where you're dealing with some sensitive information on a daily basis. There is a statutory obligation to protect this information. This obligation is well known. It's been around for a long time. It's going to continue on. And as I mentioned earlier, the law errs on the side of the protection of the right to the individual as opposed to the entity handling the individual's information. So we take the view that it's worth bearing that in mind when dealing with information. The case studies that we talked to show how information can be inadvertently disclosed or threatened. Obviously, we just talked about from February next year a statutory obligation to report a data breach. This will pose a real risk to reputation if handled incorrectly. And obviously, with less than 3 months to go, we certainly recommend you start taking steps to prepare for this obligation. So we'll get to the Q&A. Sorry about that. So back to Deborah's question first. What is the line between duty of care and privacy when the police seek address details of a family member for the purpose of conducting a welfare check when the police were notified of concerns by a third party? Again, it's a good question. So I think, again, there's two ways of doing this. The family member can consent to the disclosure of the information to the police. Obviously, that is less likely to be something that's going to consent to if the police are involved. But again, there is a risk of breaching privacy if you disclose information to the police without the police demonstrating they need that information. So getting a subpoena is one way of doing it. There is a potential to rely on a situation of the welfare check being needed to prevent the serious threat of an imminent threat of harm to the individuals concerned or to the public. But in our view, it would be better to err on the side of caution and get the police to give you a subpoena. They're pretty easy to obtain. the police should be well versed and handle subpoenas on a regular basis. So they will complain about it, but from your perspective and making sure you minimise your liability for a breach of privacy, it's better to have the subpoena presented to you and deal with it that way. So Christina asks, do doctors and allied health providers necessarily have access to sensitive information about residents, but the aged care provider do not have direct contractual relationship with doctors? That relationship is between the GP and the resident. Should we in fact create some sort of deal with them, requiring them to comply with their privacy policy and data breach policies? That's also a good question. From a personal perspective, I've actually been assisting some clients deal with that situation where they have gone to this trouble of creating a deed for doctors to agree to that protect the allied health provider or people working in that sector without being doctors themselves. So I think it is something that you should want to consider. Again, doctors should be fairly comfortable with signing those types of documents. So because they're starting to be asked for those types of documents more and more often in our experience. So I think it's something worth considering if it's something that occurs quite regularly and you're dealing with GPs on a regular basis and you're concerned about the protection of the information that's been disclosed to them. It's obviously worth making sure that the individuals about whom you're disclosing information have given consent. Either they give consent to the doctor and the doctor needs to provide that consent to you before making the information available, or they've given consent to you directly because they understand the doctor might be making a request. So I think the answer to that is probably yes. So I've just got a note passed to me, Melissa, and to everyone else on the presentation. There will be a URL to download the PowerPoint presentation emailed to participants at the end of the presentation. So you should be able to access the slides post the webinar. And Kerry's asked, should her organisation be training new and existing staff on the privacy law? We would recommend definitely, because ever since the new Australian privacy principles came into effect almost 4 years ago now, there was an expectation under the Privacy Act that staff are trained on privacy and their obligations, or the obligations of the entity in relation to privacy. A lot of entities think that having a privacy policy is the be-all and end-all. That was probably the case under the old legislation. It definitely isn't the case now. And with the mandatory data breach notification laws coming into effect from February next year, having staff being able to identify a potential data breach or risk of a data breach occurring is useful in nipping it in the bud, as I mentioned earlier. So at the moment is all we have in terms of questions. Just have a quick squeeze at the time. We've probably got about 5 minutes left. So if you have any more questions, now is the time to do them. In the meantime, we might see if we have another poll to get going. We'll start this one in relation to new starter induction using online training. So that's just gone live. And in the meantime, please feel free to answer some further questions. Just take the moment to have a drink of water because it's been a long time talking. Just having a look at the poll numbers dance up and down. So thank you for answering the polls that we've asked you to date. It's been a really useful situation. So Bridget's asked, what are the top 3 takeaways? It's a good question, Bridget. I think the top 3 takeaways are probably we're starting to run short on time on the data breach notification laws, which if overseas experience is any indication, so the US has had data breach notification laws in place for some time, and talking to some practitioners in that area over the past few years, it's really been interesting to see the level of litigation that follows a data breach. Not so much in the health and aged care sector, but people might recall a few years ago, Target in the US suffered a really extreme data breach where a lot of their customer credit card details were stolen as a result of some malware that was installed without Target's knowledge in their systems, and it resulted in a lot of litigation between Target and the banks that issued the credit cards. The CEO of Target resigned as a result. So it's useful to understand and get on top of the data breach notification laws between now and February next year. So Vicky May has asked, what additional precautions should we engage when managing student placement? It's a good question, Vicky. Again, I'd be treating students who have been placed into the workplace just like any other employee. So making sure that their personal information that they give to you during their time is handled appropriately, it's protected, and when their placement is over, destroying or de-identifying that information if you believe it's not necessary to hold on to. For example, you've decided you're not going to offer them employment into the future. So just treating it like any other personal information. Diana has asked, what are the considerations for a hospital that misplaces or loses a patient paper medical record? I possibly misfiled or in a cupboard somewhere, or a doctor has taken it home. Is this a potential notifiable breach? Very good question, Diana. People might remember earlier this year, John Faulkner Hospital managed to lose a whole bunch of paper records from patients that were left out in the street. They chose not to comment on that at all, even though it made the papers. It depends on the circumstances of the misplacement. If you find it depends on where they get misplaced. So if they're in the street or if they're in a publicly accessible area of the hospital and you believe that members of the public have had access to the records, then potentially it will be a data breach that needs to be notified. So as I mentioned, it will depend on the circumstances, but potentially it will be a notifiable breach. So Alana has asked the question about what sort of fines are likely to be imposed. It assumes it relates to seriousness or impact or scale of breach. Alana, yes, your assumption is correct. The top end of the fines are reserved for particularly egregious breaches of privacy. So if an organisation persistently breaches their obligations to protect information, then yes, they will start getting exposed to the top end of the fines. As I mentioned earlier in relation to the Mr. Z case study, the Commissioner does have the power to order compensation be paid to the individual concerned. Basically, it is at the Commissioner's discretion, so it will depend on the seriousness of the breach. It will depend on what steps the organisation has taken to make sure the breach doesn't happen again, whether there's been capacity to conciliate the breach with the individual concerned. So a lot of factors will go into determining the scope of the fines. So Karen has asked a question about, are there any particular issues that you think disability service providers need to be aware of given the new Quality and Safeguarding Commission and the NDIS generally? I don't think there's any particular issues that come to my mind off the top of my head. I think it's just, again, making sure that protecting the information of people who obtain disability services, bearing in mind that, particularly if they're suffering from mental disabilities and may not have the capacity to give consent to disclosure of personal information. I think that's one thing to bear in mind particularly, but I don't think that is particularly new. It's just the nature of the information concerned. So Karen has asked the question about, would it be a notifiable breach where an individual has inadvertently been sent another person's information? Potentially, yes, if you have discovered it too late. If you discover it, almost immediately and you're able to retrieve the information from the individual, or they've given undertakings potentially that they've destroyed the information or destroyed the email in which the information was protected, then potentially you may be able to not have to report the breach. But if you discover it well after the event, then most likely you would need to provide breach notification. But again, it will depend on the circumstances. I think we're just about out of time. So thank you for your attendance. It's been quite an interesting experience for me to go through the webinar. It's the first one I've done of this nature. We do want your feedback. So there's a short survey accessible through the webinar channel. So please, if you take the time, it should only take a few minutes to complete. We'd really appreciate your responses. And thank you again for your attendance.